Ready, start. Appellant has contended that High Court erred in holding that the appellant number 1 cannot be declared as the wife of the deceased Subedar Bhave, on the ground that their marriage had taken place during the subsistence of his marriage with Ansuya, full stop. He submitted that the embargo placed under Section 5 within bracket 1 of the Hindu Marriage Act, 1955, that recognizes a marriage solemnized between any two Hindus on the condition that neither party has a spouse living at the time of marriage, would not prejudice the case of the appellant number 1 for being recognized as the wife of the deceased in view of the long period of cohabitation between them, which circumstance would attract the presumption of the marriage between the parties being legal, as contemplated under Section 114 of the Evidence Act, 1872. Full stop. Section 114 permits the court to presume the existence of certain facts which it thinks are likely to have happened in relation to the facts of a particular case. Full stop. It was contended that the said presumption of a legitimate marriage between the deceased and the appellant number 1 become stronger in the instant case as during his lifetime, the deceased had approached the respondents with an application seeking endorsement of the name of the appellant number 1 in his service book. Full stop. It was further submitted on behalf of the appellants that even if the status of the appellant number 1 could not be treated as that of a legally wedded wife of the deceased till the date a decree of divorce was granted, dissolving his marriage with Ansuya, after the said date, that is from 16th November, 1990, till the date of demise of the deceased, admittedly, he and the appellant number 1 were cohabiting, thereby entitling the appellants to claim the pensionary benefits of the deceased. Full stop. It was also pointed out that at no stage did the first wife, namely Ansuya, lay any claim to the pensionary benefits of the deceased, and therefore, the respondents ought not to have turned down the legitimate claim of the appellants, more so, when the appellant number 1 had spent a large part of her life living with the deceased as man and woman, and any shadow cast on their relationship stood dispelled once the decree of divorce was passed in November, 1990, dissolving the marriage of the deceased and Ansuya, full stop. On the other hand, Mr. K.M. Natraj, learned additional Solicitor General appearing for the respondents, has supported the impugned judgment and submitted that the marriage between the deceased, the appellant number 1, and the deceased is a void marriage under Section 11 of the HMA, as the said marriage was contracted during the subsistence of the marriage between Subedar Bhave and Ansuya. Full stop. He submitted that the said void marriage cannot be given a legal sanctity on the basis of the subsequent dissolution of the marriage and cohabitation of the deceased and the appellant number 1. Full stop. Learned ASG also referred to Regulation 219 of the Pension Regulation for the Army, 1961. Full stop.